The following program is sponsored by The Greek, Ely's Radio Shack dealer at 570 Altman in downtown Ely, and brought to you as a public service by Georgetown Media in Ely, Nevada. Ely City Council Special Meeting, August 11th, 2020.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call.
Mayor Robertson,
Present.
Councilman Fligas,
Here.
Councilman Carson, Councilman Spear,
Here.
Councilman Oliver,
Here.
Councilwoman Beecher, here, City Attorney Thompson, here, City Treasurer Trask, here, Public Works Supervisor McCracken. That's all, Mayor.
Thank you. We'll move on to item 2, public comment. Please state your name for the record. You have 3 minutes.
Thank you, Mr. Mayor. Mr. Mayor, there was nothing in the packet for today's meeting. I picked up my packet 2 days ago. How can you make a decision without reviewing the material? I see it was personnel manual, which I was given today, and one that's to be amended. When did you get your packet? I should have got mine at the same time. Mr. Mayor, what is the total debt today of the historical railroad? What is the total amount paid to date for legal fees involved in the SNS lawsuit? Was a bond required for the bookkeeper or accountant who was in charge of collecting railroad monies from the SNS shoreline? If a bond was required, did anyone file an action? An action allows for pullback either by the city or the railroad? Mayor Robertson, Councilman Beecher, and Councilman Allworth, you all have a fiduciary responsibility to the city. There may be millions of lost revenue or legal fees involved in the city and the railroad. You have an obligation to the tax director to report the financial concerns. I've asked in the past this question numerous times. You didn't answer. Mr. Mayor, once again, I'm requesting a complete list of all liens the city has settled in regards to water, sewer, landfill fees, and any penalties and interest that may be related. I want to know the amount collected, who made the agreement, and the date it was paid. Mr. Mayor, the city is not treating everyone the same. In the past, I was not allowed to pay my utility bill, and the city clerk refused to take my payment. When I refused to leave without a receipt, the city clerk called the sheriff's office, and I was told to leave by a deputy or face trespass charges. I was removed from City Hall on 4 different occasions. The city is selectively enforcing the law, the ordinances, under color law, and that needs to stop, Mr. Mayor. Mayor, I've asked in the past and asking again in regards to the rumored embezzlement of tens of thousands of dollars from the railroad. Is it true? Did the city, would the railroad file a claim of pullback? Your insurance carrier? If so, what was the amount collected? When was it collected? If not, why not? Mr. Mayor, what is the total debt today that the railroad has on its books? I've asked numerous times and I've never received an answer. You need to know. They're going to put the city on its knees, if not underground. Mr. Mayor, several months ago on December 30th, 2019, billings, the city paid Brett Brothers LLC $11,500 for patching at the carpet plant. Why are you patching on private property? When was it put on the agenda? When was it approved? Who approved it? I've yet to get an answer in my lifetime. Mr. Mayor.
Thank you, George. Any other public comment? Seeing none, we'll move on to item 3. For discussion, possible action only of the Ely City Council. A, new business. Item 1, council members, city treasurer Trask, Full-Pack HR business partner Newell, Freitas discussion only, review of proposed changes to the City of Ely personnel policy management.
Okay,
Take it away.
take it away.
Since this is just a work session, I guess any questions is just for clarification, and I might interject a little opinion here or there about different policies, but the last record that we have of when the policies were passed were back in 2014. And every year, which follow PULPAC's template. And every year we do a revision that we shoot out to our members. These haven't been revised for 6 years now. So if you look at these policies as itself, I guess the comparison is my stepson, I was putting this out to him, he's into Toyota Tundras. So I'm looking at a 2014, and then I look at a 15, 16, you can't tell much difference, but if you look at that 14 and look at a 20, there's a heck of a lot of apparent differences. What you're going to see is, you do have a copy of the original one, or the current one that you're working under now. And then the one that Jeanette and I extensively worked on together. But you're going to see a lot of highlighting, different coding. You might be thinking, my goodness, what's going on here? Well, over the years, with these revisions, and the revisions, some of the notes, the revisions I have in here, they're color-coded in blue, which is just revising the current language. The green is totally new language. Over the years, PULPAC, when we're revising our policies, we're trying to refine them and get them into their best, into the best format or easily used by our members. We really stress the importance of policies because, especially in organizations where you have your collective bargaining units, the CBAs are there to protect them. These policies are to protect the organization. And if they're not up to date, if they're not current, or they're lacking some, legislation that needs to be in there. Every 2 years, as you know, the legislature's come up with a few new rules that they stick in here. Since 2014, I would say you're going to see about 3 or 4 inclusions of a new policy that needs to be adopted by NRS. So with that, I guess, are you comfortable if we just go page by page and I'll refer to you? So, and please, anytime, I do have to qualify. Every time I do a training out here in Ely or anywhere, I have to explain. I overheat, so if I'm sweating or whatever, it isn't from council intimidation or fear factor there. I can't hear in this ear, that's why Jeanette's here. Anyway, but I have a hearing aid that has an amplifier here, a receiver here that transmits here. So sometimes when somebody's talking, I'm catching it here, and I think it's coming from over here. So Ernie, if I'm asking you, could you say that again? And really, it's Jim over here asked it, just point to Jim and I know. Okay? Anything else that I usually cover? Okay. So the first page is going to be, of course, the general provisions. As you can see here in the green, the added language on the new one. Right. I'm sorry. Cut through all the table of contents.
Which will be updated when we get one.
Nathan, do you have copies there?
I got it.
You got it? Okay. As you can see, the purpose is the same, but we did have the language in here, almost a similar language you're going to see in the CBA. It's telling you what the city has, what rights we have. Determine qualifications of employees, to refine and everything else. So I'm not saying that that's put in there, but that's put in there for your protection. It kind of sends a message, you know, we control, we run the city. Any questions on that? Just about, I don't know if you've read it or whatever, but it's just more clarifying just what your role is in the managerial or in the governing position. The next one down in the scope is the same. The next one under 1.3, we realize that most of our policies, none of our policies had the computing of time notices. What are we going to say when we say it's going to be out in the mail, or when's a work day, or when we say something, close of business is going to be at this time or whatever. Now, a lot of times, I think in your CBAs, it's going to say what their work weeks are. It doesn't, I don't think it addresses specifically what the hours are or whatever, I mean time-wise, 8 a.m. to whatever. But this kind of talks about commuting the time for that. Did you get to turn that page? Okay. As you can see on the next page, on page 2 of the new, and I'll say the new as opposed to the current. In green there, like I said, that's new language. In the old, I think it says the employee may return, or this is under, this isn't going to work. Administration. It says here that the employee should return. We're saying they must return acknowledgement of these put in the personnel file. That just is a safeguard so someone doesn't come in and say, well, I wasn't made aware of it or whatever. It was all new to me, and we have them signing a policy acknowledgement along with their job descriptions as well. Everything else is the same through administrative directive, change of address, and failure to receive notices. The next section under personnel file. If you look at the old file, I'm going to talk about the current policy on page 2. It is, I won't even say it's linear because it goes back and forth. It talks about medical information, it talks about who has access to this file or whatever. So over the years, we developed it and kind of streamlined it into more of an orderly fashion, and that's why it's in blue here. It's the same information, it's just been revised down into hopefully a easily understandable format. And also, as we go through this, you're going to see little places where I might say we've taken that out because it's addressed at another section within the policy. Like in one of the apparent one is access to the files or access to the personnel files. That's usually towards the end and who has actual access to the files. Sometimes an employee wants to come on in and say, or someone that didn't get a position, an applicant will come in and say, I want to see those score sheets. I want to see what Nathan put down as a response or whatever. Per this policy, it says that's confidential information. The only one that's going to be able to have access to it would be Jeanette, would be not even the board as a whole unless it gets subpoenaed. Or the only way the applicant's going to get a hold of that is if he gets a lawyer, there's a court order to present that. But that's how it's defined in here, how we hopefully presented it in such a way it's easy to use. Not only for for Jeanette and wherever the supervisors, but when we're pointing to the employees, and we really encourage them, read the personnel file. I mean, not the personnel file, read the personnel policies. So often, some folks would say it's almost kind of like some of the laws in place. Well, common sense says, well, there's a reason why these policies are. Sometimes it might go against what people think common sense is, but there's a reason for them. And usually it's all based on liability claims against organizations. So we put these steps in place. That's the other thing that sometimes governing boards might say, it's just so cumbersome. There's too many of them. Well, really, there's a reason for it. It's because of protection. And a lot of times it comes down to that fine line of, well, it wasn't addressed, it's not policy. It's not policy. So, is there any questions on the personnel file? The last thing
Which is on page 7 on the new one.
is page 7, because it isn't in the current one, is the disposal of personnel records. Now, it used to be all personnel files, you had to hold on to them for 30 years. Now, they realized, that's a long time to hold a personnel file. It's only for 10 years now. And that made Jeanette's day when she found out about that, because you should be purging all those old files. Especially if someone wants to come back and say, claim, well, you know what, 12 years ago when I was working for the city, this happened and it's in my file. Well, by law, by NRS, after 10 years, you can discard them and destroy them. If you have them, and the former employee knows you have them, you can't say, well, you know what, we can't provide those because it's been 10 years. So that's why we say, as soon as somebody terminates or resigns or retires, on their folder, the personnel packet, all of their information, whether it's medical files, the personnel files, you rubber band it up, and then you just project out 10 years from that date. And when that date comes, you can continually just be purging the folks' files. On page 8 of the current, this would be page 8 of the new, since 2014, they've added a few more protective classes, and that's why it's in the green up there. Gender identity or expression came about since 2014. Political affiliation, membership in the National Guard or any other class that becomes protected by federal or state law. In the past, we thought, well, okay, these protected classes are pretty solid, and it seems like every couple of years there's a new protected class. So that's why we added that little claimer in there about, or any future protected class. Now, one of the things, I'll go ahead and say this in the beginning, one of the things you're going to notice, instead of us in some of the policies, whether it's harassment or some of the other ones, instead of listing all of those protected classes that we have now here, we just say protected class, membership in a protected class, even though some of the policies actually might still say what they are at the beginning. Any questions on that? And these are by law. You have to have that by federal and also by state law. The new language under the city will, on the very first bullet, which is the first number 1 in the current policy, since 2014, a couple NRSs were put in place. The city cannot discharge, discipline, or discriminate an individual because of domestic violence, which we'll talk about. There's an actual policy for that. Discussing compensation. It used to be, or I guess some organizations have told employees, I don't want you discussing your pay with anyone. That's between you and the boss or you and the city and everything. You can't do that. You can't do that. It's public record what people make and everything else. And if you retaliate against an employee from saying, you know what, Jim, I'm making more than you are, what do you think about that type of thing? And someone says, well, you know what, well, we'll just solve that. No one can talk about their salaries. You're limiting people's freedoms or their rights. And the other one is then, the last one, which is a policy in itself, all of these are going to be within the policy, is the using of leave for National Guard members. You can't retaliate. You can't say, well, okay, you've been gone for the 2 weeks, you've been gone for whatever for National Guard. We're going to give you some extra assignments to do or whatever. But that's what that protection is in there. And like I said before, sometimes these are head scratchers saying, well, why? It's because there's been a lot of adverse retaliation against people in these protected classes here. The next one is just by statute, you have to have it in there regarding the National Guard service.
Bill, Jim had a question.
Yeah, got a question.
Sure.
On that domestic violence, say it's whatever it might be, the third time he's convicted of that, goes to prison.
We'll get, can I address that when we get to the actual policy, Jim? This is just saying that you can't, the victim of domestic violence is, well, dress him out. It's the victim. If all of a sudden, I won't even use any of your names as hypothetical because I always end up tripping over myself. But I'll pick on Kurt. Kurt's not here. So let's just say Kurt is a victim of domestic violence, and he works for me. And you know what? His significant other or whatever is continually coming to work, creating a disruption and everything else, and I'm taking it out on Kurt. Saying, you know what? You better get your house in order because it's creating quite a disruption here. Otherwise, you're going to have to take some time off to take care of it. Or the other hand is, let's just say, Kurt, if this is all being recorded, I apologize, Kurt, if I'm embarrassing you, but let's just say Kurt comes to work and he has bruises. It's obvious that there was some physical violence against him. And I, as his boss, and Kurt might be that front desk person. And I say, you know what, you got to go home and take some sick leave until you heal up, folks. They're the victim. So we can't do that, okay? The other thing is, when it comes to this now, sometimes the victims of domestic violence will come in, they might have done everything, have the restraining orders and everything else, and they're entitled to what are called reasonable accommodations. So let's just say, for the time being, I'm that front person that's in the counter here taking the bills and everything else. And I've done my job. Just because of a restraining order isn't going to prevent, my spouse or my significant other from coming in. So I might say, you know what, can I work from the back there or whatever? And that's where Jennifer or Jeanette, whoever the supervisor is, can make that, if it's a reasonable one. If it creates an undue hardship, then not. But that's what it pertains to, is the actual victims. Any other questions on that one? One of the other things under scope, which is 2.1.2 on page 8, but page 9 in the blue. When I was talking with Jeanette, jail policy doesn't address volunteers. And my understanding is there are some times when volunteers are used.
We do, and I'm going to recommend that we include the volunteers now in our policy between the EMTs and then any of them that are regulars, like out of the animal control. I think they need to get in our policy read, signed, so that they understand what we expect from them, or what they're required.
And usually it's following the same, and we'll get to that section as well. But once again, this is just for a review session to keep in mind. Going on down to the Equal Employment Opportunity Officer designated. I think the language is similar, that's why it's in the blue. The designated EEO officer for the city is, what are you, Jeanette? City Treasurer and HR. The next one on 2.2, where it's unlawful harassment in your role, we say anti-harassment. The reason for that, it's a legal thing, and I'm sure Caroline and Michelle's husband knows about this. We can't make, if we're trying to discipline someone for a policy violation, we can't determine if it's unlawful harassment or whatever. Only a court's going to be able to do that. All that we can base ours on is anti-harassment. It's based on behaviors. And the reason why we did change it to anti-harassment, because it was challenged a number of times. Well, prove that I harassed. Prove that it's unlawful what I did. And the organization was stuck with their hands in their pockets going, well, I guess you have a point there.
If it's in red, it will eventually come out.
Well, go ahead, say that.
Isn't anything in red will disappear?
Right. That's just for a little side note or whatever. And also what you're going to see as we go through, and this is where there's going to be a change. You currently have your the unlawful harassment, or it's going to, hopefully you'll say it's anti-harassment. We're presently, you do not have a bullying policy. So what you're going to see is, and it's totally left up to the council, is our new policies. We used to have harassment and bullying. We used to have harassment, employees' responsibilities, supervisors' responsibilities, bullying. employees' responsibilities, supervisors' responsibilities, retaliation, investigation. And we combine those because it's the same process. And sometimes when you keep two mirroring policies, sometimes one gets revised and the other one doesn't. And pretty soon there's that contradiction in language that creates headaches for Caroline and for you guys when someone comes and says, hey. The next one, anything so far? If you see, like under policy of the current 2.2.1, the policy, you can see once again, it has a listing of all of the protected classes, where in the new, we just say creating a intimidating, offensive, or hostile environment based on the person's protected class membership. Doing good? Everyone with me so far?
So far.
So far? Well, we're on page 10, and we only have 150 to go. No. One of the things on the training, this is going to get confusing. If you look at your current policy on page 12, up at the top there is the training. This is exact same language except for prohibited conduct and behavior. If you choose to adopt the bullying policy, the bullying would be included under that prohibited conduct and behavior. One of the keys, and here's Neil interjecting his opinion, a lot of times the reason why I encourage people, some people will say, well, you know what, isn't it the same behaviors? Well, harassment, discrimination, remember it's key that it's all based on the membership in that person's protected class. A bullying, you can have a bullying that doesn't discriminate, doesn't meet the definition of whatever of harassment, but yet I think there's a sentence in here, or any like behavior in a harassment. This really defines it and gets a message across to the employees as well. You know what? Because there are some savvy employees out there. I can ask some folks, maybe not here, but in other organizations, that they know the book, and they'll sit there and say, well, it's not harassment because it doesn't meet the definition of harassment because it isn't based on your membership in a protected class. So I can be a jerk all I want, and sometimes they are. So that's where that language is at. Now, the next thing you'll see is, we'll go back to page 9 of the new. And if you guys need to take a break and say, Neil, slow down, we're reading that across on here, that's fine. What's that? Okay. Am I talking too loud?
No, you're good.
I'm just fine? Ernie, I'm doing good? Okay. Prohibited conduct and behaviors. One of the things, it's almost like I'm doing a training now. One of the things that we really stress when I come out and do the unlawful harassment, anti-harassment and bullying is, I can establish what someone's intent is, why they did something. Jeanette might say, well, the reason I did that, I wasn't trying to harass you or bullying you in any way. All I said was this, or all I wrote was this. My intent wasn't to do that. My intent wasn't to do that. I'm a former junior high principal for 14 years, and so it's kind of like discussing sometimes with employees, like with junior high kids. Doesn't matter what your intent was, you still threw the rock. So with the employees, it doesn't matter what your intent was, we're basing it on your behaviors. Okay? You exhibited these behaviors, it's in violation of this policy. So that's what those are, is those prohibited behaviors. And those prohibited behaviors are also for, you're going to see this is for the harassment and this discrimination. But if you flip over the page to page 10 of the new, you're also going to see they're pretty similar to the ones on bullying as well. The bullying, it was kind of also, you're going to see the added language of sabotage or whatever. Sometimes it doesn't, depends if Jeanette and I are working in the same office and all of a sudden she and I have a little tiff. And whenever she goes and leaves the office, I go over and plug her computer, even though it stays going for a while, pretty soon everything just dies. Well, I'm sabotaging her work, and that would fall under the bullying policy. But that's why we've separated them out. The next one on the new page, on the new one on page 11, the dealing with allegations is the same on page 10 of the current, except on the current one it says dealing with allegations of discrimination and or prohibited conduct and behavior. We just say we leave out the discrimination because discrimination is a prohibited conduct. So that's why we've changed it to that. The process that's in place, this is for both the bullying and also for the harassment. We've changed, the language is, similar, and that's why it's in the blue. So once again, we didn't put in there all of the protected classes. We just said to their membership. Am I doing good? You guys still awake?
Yeah.
Okay. Is it too hot in here? You guys think? What's that?
I said I can get a fan.
Okay. I overheat, like I say, so most of the time when I ask, is it too hot here, people will say, no, it's just comfortable, and it's okay. Customers are always right, I guess. The next area on page 12 is going over the responsibilities. One of the key ones under the investigation, you can see on the new one of 2.4.4, which is the same as you. I apologize because I was wrong on this. You do have a bullying policy. We just combined it. Okay, so. Okay, so on page 11 of the current, and we're on page 12 of the new proposed one, under number 2, which would be the second paragraph, we've taken out, if you look, this is one of the, on that second paragraph, we took out the second sentence where it says, employees will be strongly advised to refrain from discussing the subject matters with others, particularly while the investigation is in progress. We would like to say, you know what, for the time being, mom's the words on this until the investigation's over. You can't do that. There's a, what is that? Constitutional right. People have freedom of speech. I can talk about my workplace, anything that's going on. Nor can we encourage, but the understanding is, you know, we're doing an investigation and we want to give everyone a fair shake so we don't jump to conclusions, but we can't tell someone, I don't want you discussing this until the investigation's over. The other thing is sometimes employees will say, well, is the information I'm giving you, will it just stay between you and me? Jeanette, you promise you're not going to tell anyone? Well, you can't guarantee that. You can't guarantee confidentiality. You can always encourage folks that we do the best we can, but we can also say we are very proactive when it comes to retaliation, which is listed here as well, prohibition against retaliation. The other one down is, if you look at the 5, the 5th paragraph, where it says on the old, on page 11, 11, if it is determined as compared to the new, we just changed the language there. As you can see here, it says we'll take remedial action against the violator commensurate with the severity of the offense. We're just saying the employee will be subject to disciplinary action up to and including termination. We already talked about the training, which you'll see in the old on page 12. The next one is the prohibition against retaliation. That language is the same. Your employee dating policy is the same. And as you can see in your old policy, it went harassment, employee dating, employee bullying. We put the harassment and the bullying together, and that's why employee dating comes afterwards. On your old policy on page 14, when it comes to employment disabilities, this is the same as on the new on page 13. This, as you can see in the red there, it talks about that we remove this first section of the purpose of the policy. Now remember when I was talking about the personnel files? That language is covered there under point, and if you want to look at for the reference, is 1.8, and if you want to go back after the review session today. The language in the policy is the same. If you look at 2.8 of the old, determination of disability, it goes from page 14 to 13, which lists different qualifying conditions for ADA. I guarantee you since 2014 until now, they've just added just about everything to the ADA. So instead of that, you can see our language is just saying that limits one or more major activities, has a record of being an impairment or being regarded as having an impairment. We don't list those because it's hard to stay up with those. It's almost like gasoline prices. We also, under where you'll see on the old, the disability-related inquiries, we remove the language of the 3 stages of employment process. That's going to be covered under the section when we talk about employment, the process they have to go through. We also added, and that is new language down at the bottom, at the very last, on the current policy, under 2.8.4 on page 15, that third paragraph. We extended also there, the city may require the employer to provide a fitness for duty certification. And we added the statement, to pose a threat to himself or others inconsistent with the business necessity of the city. Sometimes folks are so eager to come back, especially in the ADA covers people that have had surgery, that have had going through some possible rehabilitation, physical or whatever. And sometimes people are so ready to come back, it's kind of like they're coming back a little bit too soon. And sometimes we're aware of that, and we want to say, well, the last thing we want to happen to Jeanette is, even though she's eager to come back, whatever her job responsibilities are, we might say, no, because there's a likelihood you can endanger yourself but other people as well. So that's why that's in there as well. Your 2.8.5 of the current policy, we removed that because that is now covered in the confidentiality of medical records under the master personnel file in the first policy, section 1. The accommodation for applicants, all of the language is the same there as well. The requirements of other laws is the same. Now, on your current policy, 2.8.8, the glossary of ADA-related terms, on page 16, 17, until the top of 18. Well, at the end of the policy book, there's also definitions and everything else. That's where it's addressed. We felt it wasn't necessary to have that in the actual language in the policy when it's a glossary. It's definition, so it's in the back. So that's where it's been removed, and that's where it's been placed now. As you can see on the new policy, on the new version that you're presented with right now, in the green is a pregnancy, childbirth, or related medical conditions. This is a required policy. It came about because of with the inclusion of the Federal Pregnancy Discrimination Act and the Nevada Pregnant Workers Fairness Act under NRS 613. And when I present policies, it doesn't mean you have to follow the exact language, but you need to address that by law in your policies. If you look at on page 17 of the new, the other one is, Jim, this is where on 2.8, this is the reasonable accommodations for victims of domestic violence. That's where that one's covered. Good. The next one that we're going to get into is a drug and alcohol-free workplace. And since 2014, not much has changed, has it? Oh, wait a minute. Recreational, medicinal marijuana is now legal, and that some employees are under the impression, well, it's legal. That means I can light up whenever I want. Alcohol is legal too, but you're not allowed to have that in the workplace as well. One of the things as I go through this, even though it might be legal, recreational, and medicinal, does the city receive any federal funds, grants, or anything like that? Yeah. Yep. Well, on the federal level, it's still considered what class or Schedule 1 or Schedule 2 drug is marijuana. What you're going to see in here is we shifted the language. No longer are we saying it's illegal, we're saying it's a prohibited substance. Okay? So with that said, the very first, I'm sorry.
Phil, how does this apply to prescription medications that may impair them?
I'm sorry?
How does this apply?
We'll get to that. It's going to talk about as well.
Okay.
We added the language that this policy, like all policies, applies to volunteers as well as the employees. You notice the language, and this is where it's, what's in green is just like the first down at the bottom of 18, you're going to see drugs or prohibited substances. The added language for the purpose of this policy, illegal drugs includes those classified such under local, state, or federal law. Prohibited substances include medical and recreational marijuana, including any product which contains a concentration of more than 0.3% THC, such as a cannabis oil, CBD products. We had a situation with one of our other members that they were doing random drug tests, and one of the people in a safety sensitive position was saying, well, they were saying I was just using the CBD oil, and it says THC free. Well, they can't guarantee that it's THC free, so this person tests positive, even though, well, they'll bring in the stuff that says THC free. Well, your drug test is going to come back with THC levels, so they still proceeded with that. So when people raise their hands during my trainings, I'll let them know that. That's not a guarantee. It isn't. It isn't like burning off all of the THC so it isn't in there type of thing. So they need to be aware of that. Here it is, Nathan. The prohibition also includes using over-the-counter medication contrary to manufacturer's instructions for consumer products not meant for human consumption. So what was your specific question?
Prescription medications that may impair their abilities.
Okay, one of the things, and we'll get to that when we get to employees responsible, well, I'll speak to it now. If, let's just say you go to the doctor, you're working for me, and you're in a safety sensitive position, or you're using in charge of a front end loader or something like that. If you go to the doctor, it's on you to ask the doctor, will this medication you're giving to me have any adverse effects? Will it affect my ability to perform my job? Okay. And the doctor's going to tell you that, whether you choose to disclose that or not. If all of a sudden, God forbid, an accident happens, you get tested, and you say, oh, well, it's this medication I've been on. Did you ask the doctor? Well, no, I didn't. Well, in here it says the employee's responsibility, and I really stress that, is you check with the doctor. If they don't, then it's a violation. When it comes to a violation of a policy, it doesn't mean that they have to be, that criminal use of drugs or whatever. It's just they need to know what's in place to prevent you from injuring Jim or Ed or whatever. That's that safeguard in place. Now, when it comes to a worker going to a doctor, say you go to the doctor, when you come with that information, the only thing you need to do is come to Jeanette, because she's HR, is just say, I have a condition, the doctor says I can't do this. She can't say, or I'm on this medication, you're not going to say what the condition is. She can't ask that. And that'd be a HIPAA violation or whatever. And then she would say, well, if you can't use that front end loader, Jim, I'm sorry, you can't use the front end loader. Is there any other work you can do? No, I'm sorry, there isn't. Well, you're going to have to take sick leave in the meantime to cover that. And that's where that catch is that we find, because if I don't have sick leave, or I just might say, or I'm unaware of this, we all think we're capable sometimes, but we're not when we're under some medication, whether it's nose drops or whatever, it affects us somehow. But that's listed in here under the employee's responsibility. And you can meet me or pick me whenever you want. I know I get kind of long in the tooth sometimes. We also added, if you look on page top of 19, once again, we use the term prohibited. Remember C there is driving an organizational vehicle while on or off duty with a blood alcohol level of 0.02 or under the influence. Sometimes when folks are on city business or whatever, they're going out to the area, they might be off duty, but you're in a city vehicle or using city property, it still comes under that. Reporting requirements, once again, that's going to stay the same, except we add a prohibited substance. Down at the bottom of 19, we have that statement actually that we're saying because the city receives the federal funds, it's listed as a Schedule 1 or 2 drug, the marijuana, and some of the other drugs listed there as well. Employees' responsibility, Nathan, this is where we talked a little bit about, or what I was getting to. We added, on number 2, we added the language regardless of the amount. One of the biggest things is, of course, pain medication. And employees sharing that with coworkers, not to be illegal or malicious or anything else, but sometimes it's hard to either schedule a doctor's appointment, but really stress that to the employees. Don't be sharing your pain meds. Yes, you might have a similar backache or whatever, but everyone reacts differently. On number 4 there, we ask, it's a responsibility and obligation of employees in safety-sensitive positions. And Nathan, this is what we were talking about, and in the blue, that they check with the HR director, let them know. And sometimes it's a temporary thing. Sometimes it's still the medication, that titration going on, they build up that resistance or whatever. We added new language on number 5 there.
I got a question, Neil.
Yeah.
With the HIPAA laws, is it still required in here somewhere that, say I'm on pain medicine, that I should tell my employer, hey, I'm taking a medication in case, I'll get into a fender bender, and I've told them about it.
Right.
If I didn't tell them about it, would I be in trouble, or the HIPAA prevents me from telling
Well,
them?
you don't have to say what your condition is, and you don't even have to say what the medication is. It's just saying, I'm on pain meds, or the medication that I have, like the little pill bottle, I have all those little pastel-colored tabs on them saying, don't drive, don't make decisions, don't do this type of thing. That they need to be aware of that. As you as an employee need to be asking your doctor, hey, I do this. Is this going to affect this in any way? Causes drowsiness? Well, I drive a semi. Well, then the doctor's not going to say, let your employer know. The employee should be letting the employer know. That, like I said, is one of the hardest things because sometimes folks can't afford to take off. Or their biggest fear is, and I try to tell this to supervisors, keep in mind that if we say there isn't anything they can do, it might just be temporary. They might not be on that front end loader. Well, they might be on the end of a shovel, okay? Unless they pat themselves in the head or something like that. But if not, the people aren't going to let Jeanette know. It's serious. Not only could they harm themselves, but then someone else on the crew, and that's the last thing we want. But once again, these were for safety-sensitive positions. And in some organizations, safety-sensitive also includes the IT people. I mean, even though it isn't, they talk about the definition of safety-sensitive is, create, we're under the impression of if it creates a physical harm to someone. Well, it can create not only a physical harm, not only to employees, but if all of a sudden I'm losing passwords and everything else and it affects the organization, that's why some organizations have the IT people or people in other positions actually listed as safety sensitive. We also listed in here under number 5 are operating heavy equipment because most policies it just says driving. Well, okay, that's fine, but you know what? I work with trash compactor out at the transfer station, landfill. Okay, and you might get an employee who says, you know what? I'm not driving, I'm not whatever, so you can't get me. And it's unfortunate that that's the reason we have in there is because it has been challenged. And it is left up to the employer to say, you know what, we might need a doctor's note before you can resume your duties. If we don't feel, just if you can't come back and say, well, the doctor says I'm fine. Well, you know what, especially in a safety sensitive position, we need a release from your doctor. Gets back to the liability thing. We're covering our bases. Employees, supervisors, we're all going to make knucklehead mistakes once in a while. But as long as we have a policy, a process in place, which we use, then the liability, yeah, there'll be some to pay, but it won't be as stringent in the eyes of whatever level of justice it goes before. We've added a few under department heads' responsibilities on page of the current on 20 to 2.3. And I think the reason why we did this to department heads I'm thinking, I'm not waiting for you to interject. What's that? Neil, say something. Okay. So the department heads, really, you only have your department, Mike's department, Jennifer's department.
As far as landfill.
But the landfill comes under Mike's, right?
Yes, so it'd
So
be.
he's the department head.
Okay, so department head, Jennifer, myself, as the
Okay.
department.
When it comes to identifying safety-sensitive positions, that's totally left up to the organization. It used to be that you'd have to have that list, it has to be published, or it had to be posted for employees for 20 days or whatever. All it is now is you have that list, it's supposed to be available to the public upon their request. we're encouraging folks when you're actually creating job descriptions, that you also list on the job descriptions whether the position is safety sensitive or not, whether it's exempt or not, type of thing. Supervisors, responsibilities, those are all the same. Employers' responsibilities, we just, similar language, except that's why it's in blue, take appropriate corrective action. Also, under the new down there, even though Mike or Jennifer or Jeanette identifies the position, the employer, which is you folks, kind of like put the final stamp of approval, are actually designating those positions as safety sensitive. And right now, you are going to look at, or you are doing random testing, right?
First,
CDL. But were you going to look at that for safety sensitive as well? Possibility?
possibility,
Right.
because I think we want to make sure that we look at what we got.
Okay.
Look at what we got for safety sensitive right now and be sure it's what they want.
Okay. Also then on page 21 of the current is the same as 22 when it comes to the EAP. We did shift over from a different EAP. We used to have resources for living. Now we're going with an employees assistance program called KPRO for all full pack members. Or were that, did you get any information? Yeah, we'll send the flyers over. Number 2, we just added the language, these situations will be addressed on a case-by-case basis. Number 3 of the old policy was removed to prevent possible HIPAA violations. One of the things in every supervisor for the city has gone through our essential management sports class. We covered the HIPAA. We can't stop an employee from coming in and saying, you know what, I'm diagnosed with bipolar, this, or this. We can discourage them from saying that. I don't want to know that. I don't want to know that. Nor can we ask, well, Jim, what are you on this medication for? Sometimes it's not, it's a slip up or whatever. Oh, you're on that, what's it for? Well, I have this or whatever. Sometimes, no, that's what you were talking about, that HIPAA violation. It's easy to cross over sometimes. Under reasonable suspicion, the drug testing here is similar. We added the language, the test may include a breath or blood test or urinalysis. If you look at the the current policy, on page 22, number 3 there, it says the employee will be suspended with pay pending results of the test. Because some people associate suspension with punitive action, we changed it to administrative leave, which people still sometimes associate with disciplinary action, but it's with pay when we put someone out for reasonable suspicion. We added the language, okay, an employee, they must sign a consent form by consenting to the test. The employee acknowledges or waiving any expectation of privacy. This is where, I keep going back to what Jim was talking about the HIPAA. Some folks have actually challenged it. Okay, you are using my drug test, a positive was a blood test. That's confidential information. That's a HIPAA violation. And believe it or not, they didn't win, but it got so far that we realized the employees have to know you're waiving all privacy when you're signing that consent form. Of course, you can't drag someone down and get them blood tests or whatever. It's left up to them. If they refuse to sign it, doesn't mean you still can't follow through with your progressive discipline. We also lined here as well that they'll be transported by the city to where they're being tested. You take them down to the hospital. You just don't tell an employee, well, head on down, get tested, come back. especially since you're using the reasonable suspicion is we're thinking because of certain behaviors, what we'll get into, they're at risk. And if you allow them to go, then what you're saying is, well, they're at risk to us, you know, we don't care about jonesing public out there. The next one. Same thing if they refuse to go to get tested, we're still going to transport them home. And if they refuse, then we just notify them, you can't, bar the door or whatever, but you can let them know then we're just going to call the sheriff's office and let them know that